This module explored the fundamental structure of licensed activity within the Arizona real estate profession, defining who may legally conduct business, what duties accompany those privileges, and how supervision and record keeping ensure compliance with Arizona law. Together, these lessons reinforced how the Arizona Department of Real Estate, ADRE, maintains oversight of the industry under ARS Title 32, Chapter 20, and Commissioner's Rules, AAC. Title 4, Chapter 28, Understanding the Difference Between Lawful and Unlawful Practice, as well as the responsibilities of both licensees and designated brokers, is essential to maintaining integrity and protecting the public. We began by defining what it means to be a licensee. A licensee is any person authorized by the ADRE to perform real estate activities for compensation, as outlined in ARS Section 32-2101, open parenthesis, 50 close parenthesis. Activities requiring a license include listing, selling, leasing, renting, or negotiating the sale or purchase of real property for others and for compensation. Only individuals with an active license under an employing broker may lawfully perform these services. The distinction is clear. If a person acts for another and for compensation, a real estate license is required. Salespersons must work under the direct supervision of a designated broker who assumes full responsibility for their actions under ARS Section 32-2153, A7, and Commissioner's Rule R4-2, 8-1103A. The module then examined the role and responsibilities of the designated broker, who serves as the cornerstone of supervision and compliance for a brokerage entity. Under ARS Section 32-2125A, every brokerage must have one designated broker responsible for ensuring that all activities conducted under the firm's license comply with Arizona law. The broker must provide reasonable supervision and control, as mandated by R4-28-1103, which requires written policies, oversight of advertising, contract review, trust account management, and staff supervision. This means the broker must review all listing agreements, contracts, and leases within 10 business days of execution, provide training to affiliated licensees, and ensure the lawful handling of client funds. The broker is personally accountable for the acts of all licensees and unlicensed employees within the brokerage. We then differentiated between permissible activities for unlicensed assistants and those requiring a real estate license. Unlicensed assistants may perform administrative and clerical duties under the supervision of a broker, such as scheduling appointments, preparing paperwork, answering phones, and obtaining signatures on prepared documents. They may not, however, show property, negotiate contract terms, discuss pricing, or collect rent for others. These latter acts require licensure because they involve representation and compensation. The designated broker must establish written policies defining what assistants may and may not do, ensuring that no one inadvertently engages in unlicensed activity. Next, we explored what constitutes unlicensed real estate activity and the exemptions to licensing. Under ARS Section 322122, it is illegal for any person to engage in real estate activity without a valid license. Violations include negotiating transactions, collecting commissions, or advertising real estate services without authorization. Penalties under ARS Section 32-2165A include cease and desist orders, fines, and potential criminal prosecution. However, ARS Section 32-2121A lists specific exemptions to licensing, including property owners and their salaried employees managing their own property, attorneys acting within the scope of their legal duties, court-appointed fiduciaries such as trustees or executors, government officials performing official duties, and employees of public utilities. These exemptions are narrowly interpreted, ensuring that only qualified individuals represent others in real estate transactions. Finally, the module examined the record-keeping and review responsibilities of designated brokers. Under ARS Section 32-2151.01a, brokers must maintain complete transaction records, including listing agreements, contracts, disclosures, escrow instructions, settlement statements, and correspondence for at least 5 years. Furthermore, R4-28-1103D requires brokers to review and initial all executed contracts, listings, and leases within 10 business days to confirm accuracy and compliance. Proper documentation ensures that records are available for ADRE audits and protects both the public and the brokerage from liability. Brokers must also maintain records of employment agreements, trust account reconciliations, and all monies handled by the firm. Failure to supervise or maintain complete records can result in disciplinary action under ARS Section 32-2153A21. In summary, Module 1.5, Licensing Activities, emphasized that Arizona's real estate licensing structure is designed to protect consumers and uphold professional standards. Licensees must act only within the scope of their authorization. Brokers must supervise with care and diligence. And unlicensed individuals must avoid engaging in any act requiring a license. Record-keeping and timely broker review provide the backbone of compliance and accountability. Together, these requirements ensure that every real estate transaction in Arizona is conducted ethically, transparently, and in full accordance with the law. Key takeaways for review. A licensee is any person authorized by the ADRE to perform real estate activities for compensation under ARS Section 32-2101, open parenthesis, 50 close parenthesis. Only licensed individuals working under a broker's supervision may list, sell, lease, or negotiate property transactions. The designated broker, under ARS Section 32-2125A and R4-2-8-1103, is responsible for all supervision, including written policies, contract review, and trust account management. Unlicensed assistants may perform administrative tasks but may not negotiate, show property, or collect compensation. Unlicensed activity is prohibited under ARS Section 32-2122, and penalties are detailed in ARS Section 32-2165A. Exemptions to licensing under ARS Section 32-2121A include property owners, salaried employees, attorneys, court-appointed officials, and government personnel. Brokers must maintain transaction records for 5 years and review executed documents within 10 business days under ARS Section 32-2151.01a and R4-2-8-1103D. Final reflection. Module 1.5 reinforces that professionalism in Arizona real estate is built upon structure, supervision, and documentation. The law clearly defines who may act as a real estate professional, under what conditions, and with what oversight. When every participant, licensed or unlicensed, understands and follows these rules, the industry functions ethically, efficiently, and with the trust of the public it serves.